thanks a lot for staying with us here at CNN News 18. You're watching the Super Saturday debate here with me, Ridhima Bhatnagar. Remember, the centre has amended rules as far as the intermediaries are concerned, and there has been a grievance panel that has been set up as well. We'll talk about that and a lot more in just a bit, but we're beginning this broadcast with some breaking developments coming in. BJP leader Amit Malviya has filed a criminal complaint against The Wire over their now withdrawn Meta report. In his complaint, Amit Malviya has alleged that The Wire forged documents with a view to malign and tarnish his reputation. Let me bring in my colleague Maria Shakil, who's joining us on the broadcast. Maria, give us more details of this complaint.
Yes, so remember, Amit Malviya feels that his reputation has been tarnished, and because he is the IT cell head of the world's biggest party, whatever implications are on him impacts his party as well. So if you look at the sequence of events, ever since Wire started putting out those stories, there was no response that had come from the BJP or from the IT cell of the BJP. So they were waiting for events to unfold, perhaps, because they knew that they were not really on the wrong. And then Wire, when Andy, who is the communication head of Meta, the parent company of WhatsApp and Facebook, they put out details saying that this is fabricated. That's when the BJP started making its moves. And now what we are being told is that Amit Malviya has finally filed a criminal complaint, the details of which have been put out by us. This is against The Wire, which is news portal's editor. And also the reporter who has filed this story, saying that this has led to a reputational damage. This is a criminal and civil defamation suit that has been filed against the Wire editors, which has been done by Amit Malviya, which also looks at forgery, defamation, fabrication, and all those aspects.
Maria, thanks a lot for getting us all those details. Let's now talk about the big story that we're tracking this evening. The Modi government has brought new rules to give people an appellate route to file their complaints regarding content on social media platforms like Twitter, Facebook, YouTube, Instagram and others. The IT rules puts the onus on the intermediary to ensure content posted on its platform is not obscene, pornographic, pedophilic, invasive of another's privacy, hate speech, promoting illegal activities or threatening the unity, integrity, defense, security or sovereignty of India. Intermediaries are now required to at least once a year inform their users of these rules, regulations and the privacy policy. Further, in case of a complaint against a post that violates rules, the intermediaries must acknowledge the report within 24 hours and resolve it in 15 days. And the complaint contains a request to remove the post when you do so within 72 hours. The government-appointed grievance committee will also be formed within the next 3 months. The notification issued by the government says that every order passed by the grievance appellate committee shall be compiled with the intermediary concerned, and a report to that effect shall also be uploaded on its website, adding that any appeal must be settled within 30 days. The MOS Electronics said that the government's mission is to provide an open, safe and trusted internet to every citizen. But the larger question is, will intermediaries actually fall in line? Let me first break down the details in terms of what are these amendments that we are seeing and what is the rationale that is being used by the central government. Let's break down those details. Grievance appellate panels to be formed by the centre in the next 3 months. The idea is to make it more user-friendly and to also have a sense that users feel they're actually being heard. The panel will review the content moderation decisions by the intermediaries. The BJP government has been very, very clear. You either follow the rules or you lose the privilege of being an intermediary in the country. Appeal against the decision of the intermediary's grievance of office will also be heard. The intermediary will have to resolve the appeal, as I pointed out, within a stipulated time of 30 days. Privacy policy should be in languages in the 8th schedule of the Constitution, for example, English and others. But quickly, we also want to talk to you about some flashpoints that we've seen between the intermediaries and the central government, and what have we heard from them in the past. For example, what have we seen as far as Twitter's case is concerned? approached the Karnataka High Court against the new IT rules by the centre. That time they had said that centre's order to block accounts must contain adequate reasons as well. Let's give you another example of WhatsApp. They had sued the Indian government over traceability clause as far as the IT rules were concerned. What WhatsApp had said at that point, that traceability against the end-to-end encryption policy. So the larger question that we're asking this evening is, will intermediaries now fall in line? Earlier in the day, my colleague Mario Shakil also spoke to the Minister of State for IT, Rajiv Chandrasekhar, on what is the need as far as these rules are concerned. Let's listen in.
My first question to you, sir, is why was this necessitated? Any particular trigger, and does it have to do with the management change in Twitter?
No, look, first of all, I want to draw your attention to the fact that the amended IT rules have been under consultation for about 4 to 5 months now, and we commenced these consultations about March, April of 2022. As I have said repeatedly, Maria, that the jurisprudence and laws and rules in the internet and tech space will continue to evolve. In May 2021, we had the IT rules that were notified then. One of the key important elements of that was to improve the accountability relationship between intermediaries and the digital nagriks that use the platforms, and a grievance addressal mechanism and grievance officers were suggested to be appointed. We have noticed since May 21 to now that grievance addressal mechanism has not worked satisfactorily, and we have received hundreds and thousands of messages from digital nagriks that either complain that the platforms don't respond, or if they respond, it's a very tokenist approach towards addressing grievances. So it is, for us in the government of India, Prime Minister Narendra Modi's government, openness, safety and trust and accountability are the three broader boundary conditions by which we do all the policies and rules around the internet. And on accountability, we believe that there was a gap, and that is why we have brought the grievance appellate committee structure, which allows every consumer who is dissatisfied with the grievance addressal process of the intermediary to appeal. We have talked about illegal content, pornography, anti-national security sensitive content. We have talked about misinformation, and we have also talked about content that will incite ill will between communities. We believe today, as a consequence of these rules, that intermediaries working with the government will make the internet and internet intermediaries operating on the internet much safer, much more trusted by the 80 crore Indians who are using it today, and the 120 crore Indians who will use the internet by 25-26.
Let me also now bring in our guest to take this conversation forward. We have the spokesperson of the BJP, Sanju Verma. We have cyber expert Pawan Duggal. We also have author and cyber lawyer Vivek Sood. I believe we seem to be having a bit of an issue with Vivek's connection, but we'll try and fix that as well. Good to have all of you on the broadcast with us. Sanju, let me begin the conversation with you. For the longest time, many have felt that there has been a gap in terms of what the intermediaries are promising in India and what the users are getting. Do you think with these amended rules, that gap will now be bridged?
You know, Ridhima, that's a very nice question, and I'll come straight to the point. I think if you go back in time, as recently as February 2021, the government had notified certain rules when that entire Twitter controversy broke out, and right-wing accounts were being banned left, right and center. You also had the ex-Vice President, Mr. Venkaiah Naidu, then his blue tick disappearing for a while. You had Ravi Shankar Prasad, the ex-IT minister, who was actually temporarily deplatformed by Twitter. And they gave a lame and flimsy excuse to corroborate their standpoint. Be that as it may, coming to the moot issue, I think, as the Information and Technology Minister, the MOS, Rajiv Chandrasekhar has pointed out, I would just like to reinforce a couple of things, that the new IT policy aims to create a safer internet, a more secure internet. It aims to rein in defamatory and pornographic content. It also seeks more transparency and accountability from intermediaries, because I think for too long, and I keep talking about Twitter because most other intermediaries seem to have fallen in line, but Twitter seems to have, it seems to be following the policy of judge bhi main, jury bhi main, executioner bhi main, though I'm sure things will change now given the new management that came into place less than 48 hours ago. The limited point is this, that, the new policy says you have to have a grievance officer that will review content, which I think is very important. Okay. And then the stakeholders can approach the GAP, the
Correct.
Grievance Appellate Panel, and depending on the kind of content that is disputed, given the kind of complaint that is made by various stakeholders, the response time could be anywhere between 24 hours to 72 hours to at best 30 days. So I think the whole issue about providing a resolution within a given timeline, within a given deadline, and expecting the intermediaries to respect the privacy and the constitutional rights of the citizens. If you read the entire amendments, which have been proposed in the new policy, it clearly says that right to privacy has to be respected.
Sure.
And the constitutional rights of users like you, me, XYZ,
Sure.
those have to be protected as well.
I think Sanju is making a very valid point. The point that the government is also trying to make, that every time a user on any of these platforms actually raises a complaint, one of the biggest concerns that are raised by users is that we don't know how long the intermediaries will take to get back and then the final resolution. The minute you put this timeline of 24 hours to 72 hours and then to 30 days, it has to be closed. That puts a lot of pressure on the intermediary to have a fixed answer as well. But Pawan Dugal, I want to bring you in the conversation as well. With the kind of changes that we've seen at Twitter, with Elon Musk coming in, anything that he does is either way flamboyant. The first day he comes, the top leadership is fired. But Sanju was making a valid point. In India, till now at least, we've seen all the other intermediaries on one side and Twitter having a slightly different stance. Do you think now it's also proving a point that if you want to have the kind of market that you enjoy in India and also the business that you enjoy because of the market, you then need to follow the rules as far as the constitution is concerned? It's that simple.
That's simple.
Well, the IT rules 2021 and now the amendments to the IT rules in 2022 have one common underlining feature, and that is, if you are in India, you have to comply with the law. Even if you are not in India, but your services are available on computers, computer systems, or communication devices in India, then you have to also mandatorily comply with the Indian law. So the argument that, look, I'm an American company governed by American laws and I will not look at your laws, is an argument that has already been thrown out of the window. It just is now requiring political will to enforce that particular legal proposition, which the IT rules 2021 and the IT rules 2022 amendments have actually brought forward. But actually speaking, from a layman's perspective, there's now far more bureaucratic setup that's been put up under these new rules than it was earlier. Look, even when these rules came up in the year 2021, most of the intermediaries only did lip service in terms of compliance with these rules, but their grievance officers would never acknowledge any grievance petition or a complaint within 24 hours. No redressal, or maximum cases we saw no redressal of grievances within the stipulated 24 hours or 15 days, as was given under Rule 3 of the IT Rules 2021. Now, the amendments say, okay, you don't comply, you come up to a grievance appellate committee, which is again going to look at the entire matter. So time is of essence, and I think this grievance appellate committee, while maybe a good strategy in terms of providing yet another effective remedy for appeal for affected persons, the fact it still remains it's going to be time consuming. True. So the ultimate objective that you wanted to provide expeditious access to effective remedies to affected persons is something somewhere trying to get lost. But most significantly, I think the IT rules amendments 2022 are even more significant because of the change of a language. which effectively has put most of the intermediaries almost in a catch-22 situation.
Sure.
Earlier, the law was very simple. You had to put in your rules and your terms and conditions, your privacy policy, your user agreement, and inform your users that they will not do certain stipulated activities.
True.
Now, with the proposed language, it's not only that you will have these terms and conditions, privacy policies, and user agreement, but you'll also take reasonable steps to not to cause
Correct.
your users to do a lot of these illegal activities.
Correct.
So
Sanju,
clearly,
I actually want to just come back to you from a point that Pawan Duggal is making, that these rules have been there in the past as well. But this time around, what has changed for the government to ensure that actually these guidelines are followed? And I'll give you an example. In the past, some of the instances that we've seen with the intermediaries, they've gone on to say that, we don't have a grievance officer here in India, so the mail trail takes a really long time. We'll get back to it. Is it now fair to say that this time around with the amendments, there is a caveat that either you follow these rules or you lose the privilege of being an intermediary? Has that what has changed now? Sanju?
Is that for me, Ridhima?
Yeah, Sanju.
Yeah, okay. I just want to make a very, pertinent point when we are discussing this issue about digital privacy and transparency and what have you. Don't forget that today, be it Facebook, be it WhatsApp, be it Instagram, all these three big social media platforms are eventually owned by one company. The holding company, the flagship company is Meta. So unless, countries like India, be it Twitter, be it Facebook, be it Instagram, the largest user base comes from India. So unless we have checks and balances in place, it is very easy for Twitter intermediaries to influence the psyche of impressionable minds. And I think that is also what is behind the government's entire initiative to ensure that the digital divide between what is right and what is wrong, what is constitutional and what is unconstitutional, what is digitally ethical and what is digitally unethical, what is digitally consumable and what is digitally not consumable. These lines are clearly defined without any opacity. And I'll tell you one very important thing. If you recall, last year, WhatsApp said that it should be given the blanket right to transfer and store data of WhatsApp users in India, and it should be fungible across other, subsidiaries of Meta. For instance, it wanted that WhatsApp data can be used by Facebook. Facebook data can be used by Instagram, because eventually all these are owned by a single company. And the government said, no, we will not allow WhatsApp users of India, their data to be stored or their data to be consumed by Facebook in any manner. And while WhatsApp agreed to this in Europe, because the European Commission said, no, you cannot use WhatsApp user database to satiate Facebook's desires to have a larger consumer base. You have to follow our European Union Commission norms. But in India, they said, no, we will not follow this. And when the government came down hard, Harish Salve, who was actually the lawyer on behalf of WhatsApp and Facebook, said that fine, we will agree to what the Indian government is saying, and we will not implement our policies until there is a digital protection law which is in place and a personal data protection law. So I think the next step is, after reining in the intermediaries to ensure that they are compliant, we have to have a data protection law which ensures that nobody's constitutional rights are breached. You are given your fair amount of privacy, but intermediaries are held to greater accountability.
Okay, I'll just come back to that point that Sanju is making, but I just want to bring in Vivek in the conversation from a user perspective. I was hearing that conversation that my colleague was having with the Minister Rajiv Chandrasekhar, and he put it very well. He said the idea is to have a sense of openness, a sense of transparency, to have an open and a more secure internet. The idea is to empower the users. Do you see that happening, Vivek, with these amended rules?
Okay. First of all, let me divide these rules into three parts. The first part is that intermediaries will publish the privacy policy and their rules of the game on the website. Very laudable, very laudable. very relevant in these times. The second part is the intermediaries must have a grievance mechanism, and there has to be timelines to it. Very laudable again. Now I come to the problem, the third part. The third part is that the intermediaries shall take reasonable steps to prevent certain activities on the internet. Now, when I read these activities, which are stipulated in these rules, they are overbroad. They violate the freedom of speech and expression. Please see, it says, the intermediary shall make reasonable efforts to prevent the hosting, display, and publishing of information that belongs to another person, which is obscene, which is invasive of another's policy, which is harmful to children. Now, these are all very vague, general expressions. I find this part to be problematic. It has not been well drafted or well crafted.
Okay.
I find this part to be another avatar of Section 66A, which has been declared to be unconstitutional by the Supreme Court in Shreya Singh's case. Now the way forward.
Okay.
See, let me point out very clearly.
Pawan,
the intent
one second.
of
Vivek,
the
I'll just come back to you.
government is
Let's
very
break
good.
it down. Pawan, do you buy the criticism that's coming in from Vivek that while the intent might be good, but the language can be problematic?
Well, I completely endorse the thought process that while the intentions are correct and noble, the effective impact of the language is that we're going to see far more litigation now. Because you are effectively making the intermediary responsible for taking appropriate steps to prevent its users from doing a variety of activities. Now, what's going to be reasonable steps is again going to be dependent on facts and circumstances of the case. So I expect far more now suing of intermediaries on the ground that, hey guys, you did not do what was expected by law for you to be doing in order to prevent such kind of activities. So that's opening up of a much bigger Pandora's box rather than this grievance appellate committee, which is a very, very small kind of a component. So the bigger component is more control of the government. Well, a lot of intermediaries says that's going to be violative of my rights. So I should expect a couple of public interest litigations now. We should go ahead and challenge these kind of amendments to the IT rules. Mind you, the IT rules 2021 have already been challenged by a couple of public interest litigations, and all the matters are currently pending before the Supreme Court. So maybe another supplemental petitions could go to the Supreme Court. But yes, the fact remains is intermediaries can always argue that, sir, you cannot treat me indifferently or separately from others as well. You can't, make me responsible for acts that I cannot even dream to do. For example, as an intermediary, how can I go ahead and make sure that my user does not do any of these activities which are given under Rule 3?
That's a good question that Pawan Duggal is raising. Sanju Verma, I'm going to give you the final word. The intent is right, but the language can be problematic, leading to a lot more litigation.
Pawan Duggal is a cyber expert, and I'm sure he knows a lot more than most of us on the panel. But I would very humbly tell him that, Mr. Duggal, in June this year, barely a few months back, the Modi government actually put out the proposed amendments to the policy out in the public domain, clearly asking the public and different stakeholders for their opinion. I hope you gave your opinion because it's very important to hear all voices. And point number 2, I disagree very politely with you when you say that it's the return back of 66A. Don't forget, it was not the Supreme Court. It was the Modi government which took the initiative to ensure that we did away with the draconian 66A, which was introduced by no less than Kapil Sibal, who today talks about press freedom. And the third point which I want to make is that there is nothing vague about reasonable policies that have to be followed by the Twitter intermediaries. They have to ensure Article 14, 15, 19, 21 are not breached. And it is because that there is room for maneuver between different stakeholders that you have a grievance officer and a grievance appellate panel, which will be constituted by a retired High Court judge and experts from different fields. So I think let us leave it to the good judgment of experts from relevant areas to judicate on a matter if it goes into a dispute.
Okay, unfortunately, I've completely run out of time. The government is saying we've done our bit. We've set the rules for the intermediaries. The question is, how will the intermediaries react and respond? I'd like to thank all our guests. With that, it's a wrap from my side. Thanks a lot for watching.